Welcome to the Information Governance Update for General Practice staff. Over the next 20 minutes we're going to look at the key issues encountered by practice staff when handling personal information. We will look at some of the legal background and recent developments, the basis for sharing information, key risks when using communications tools, the importance of quality of information, requests for access to records, and some key aspects of technical security. Hopefully many of the lessons described here will be familiar, and this will be mainly reassurance rather than learning. However, if you have any questions from this presentation, please direct them to the practice manager. Let's start with some background on what information governance is. Fundamentally, information governance is all about maintaining a balance between security and access to information. For example, every patient has a right to expect confidentiality of their personal data, but for some the practice is faced with requests to disclose information, and it can be appropriate to do that in some circumstances without the patient's consent. The practice holds personal information in a number of places and forms. Practice staff need to be able to access this information with ease to ensure that effective care can be provided. But the practice also needs effective security measures to ensure that information can't be accessed by individuals who shouldn't see it. However, these security measures should not be too stringent and impede practice staff. Often information governance is seen as a need to comply with laws and standards, with an emphasis very much on making sure things don't go wrong. Whilst that is certainly true, there's also a flip side to the coin that isn't always appreciated, in that by achieving compliance, the practice will get value from the information it manages. When processes to handle data are well thought out, and all staff are educated to a good standard, then the collection, use and sharing of information should support the business of the practice. The bottom line is that good information governance supports the right information being available in the right place and at the right time. So for all the work we have to do on compliance, there is a positive benefit to be gained as well. Let's take a look at recent developments in the legal framework. The key aspects of laws for handling information are supported by the Information Commissioner's Office. There are three aspects to the role the Commissioner's Office undertakes. In terms of data protection and freedom of information, the role is first and foremost to provide guidance, so organisations are enabled to act appropriately and effectively. They also take an active role in assisting organisations with measuring their compliance with requirements, and where required they have the powers to enforce compliance. The Data Protection Act and Freedom of Information Act cover information both in paper and electronic format. Freedom of information is concerned with organisation information and allows individuals to request information that the practice holds. Any request should be passed to the practice manager to coordinate. Over the past few years, numerous headlines about losses of personal information have brought about increased penalties to the effect that organisations can now be fined for serious breaches of the legislation, with a maximum possible fine of £500,000. Also, an individual working in primary care has recently been given a 6-month suspended prison sentence for inappropriate access to information under the Computer Misuse Act, where they accessed over 400 records of staff and patients they weren't entitled to. The Data Protection Act defines the framework for the use of personal data and gives individuals a number of rights, including a right to request access to the records, a right of correction of mistakes in the record, and some control of what their information may be used for. More detail on these rights is covered later on. Data protection works in conjunction with the right to privacy in the Human Rights Act and the common law duty of confidentiality to establish the basis for which information can be shared. An area of continual discussion and potential complexities are the justifications for sharing information. There are three generally recognised justifications to share information, and these are: with the consent of the individual, a legal duty set out in specific laws, or where sharing is deemed to be in the public interest, which is sometimes best described as to the benefit of the public, and not to be confused with of interest to the public. So let's look at some scenarios common in general practice. A husband has called and asked for some information about his wife. Generally, this should only be provided if you have her consent. In some situations, he may be her main carer, and she may lack the capacity to organise her own care, but if it's generally known that he assists with her appointments and other activities, and that she's never objected, it can be said to be with implied consent. A researcher has asked for a list of patients with a particular condition, so they can contact the patients about participating in the research programme. It's not possible that a list can just be provided, as the practice must be sure there is a basis of consent. There are two main ways to achieve this. The common method is for the practice to contact the patients with details of the research and offering patients the opportunity to contact the researcher directly. Alternatively, some practices are very active about informing patients that they are involved in research, and the practice may share relevant contact details with the researchers on a basis of implied consent, as long as the practice offers any patient the opportunity to opt out. A police officer has contacted the practice and asked for the address of a patient who is alleged to have carried out an aggravated burglary. This sort of information can be disclosed if following discussion it's felt to be in the public interest in order to administer justice or prevent crime. It isn't necessary to inform the patient or to get consent, and in some circumstances doing so may prejudice the police investigation. Disclosure of medical details is less common and will require very robust reasons, and disclosure of information relating to other parties such as victims generally requires their consent. There are some legal duties where disclosure to the police must take place, and these are in relation to road traffic offences and terrorism. But as they are uncommon issues, the best approach is to seek specialist advice at the time. Many other agencies will also seek to request and share patient information. Patients should generally be informed and consent to any disclosure, unless there is a legal duty to disclose, such as child protection, or a very strong justification such as protecting a vulnerable individual from a high risk of significant harm or abuse. Information sharing situations where it's not abundantly clear what to do are best tackled by discussion within the practice and seeking expert advice if necessary. Most staff are generally familiar with the main risks when using and communicating information, but like all other risk prevention standards such as fire safety, it's worth a quick reminder on some of the key risks. The first large fine levied under the Data Protection Act related to 2 faxes that were simply sent to the wrong place by error. A simple misdial of the number resulted in child protection legal case details being sent to a member of the public. The lack of a cover sheet also made it difficult for the recipient to alert the organisation the fax had gone astray. One instance was bad enough, but within a week it had happened again. Whilst the risk of human error cannot be eliminated, it shows the importance of using cover sheets, checking fax numbers, informing the recipient the fax is coming, dialing carefully, and checking it's been received. The phone and the answer phone can often be seen as the biggest areas of risk when communicating personal information. There are numerous cases of unwitting disclosures, and also those where practice staff have been deliberately and cleverly duped into disclosing details. In one such scenario, a teenage girl calls a practice to ask for her test results. As she can give all the correct details, such as name, address, date of birth and recent appointment date, staff may well disclose results or that some results have been received to her, only later to discover the caller was the patient's sister. One possible solution is the use of a password to verify the caller. Some odd situations can, however, be genuine. It's feasible a male caller asking about his wife's pregnancy test is generally seeking information on her behalf, so it's always advisable to discuss with the patient what information can be disclosed and to whom. Whether to leave an answer phone message of any sort is often a dilemma with no real correct answer. Sometimes even leaving a very basic message can allow others to draw conclusions, rightly or wrongly, about a patient's condition. Your practice may have a policy that no messages are left, or just simply leave a message to request to call the practice. It's advisable only to leave messages if all other communication attempts have failed and there's some urgency of the patient to be in contact with the practice. In relation to using email, spare a thought for the Primary Care Trust Administrator who was asked to send an email to everyone who needs to know. This was about an individual who was in crisis and was to be sent to urgent care centres as the individual was thought likely to present at the weekend. In the email address list she saw an entry called Everyone, and subsequently sent sensitive details to over 400 staff. The key considerations when using email are whether patient identifiers need to be used at all, and if so, just to send those who need the information, and be careful when selecting the email addresses. The National NHS mail system is recognised as secure for sending patient data, but there are other secure methods in place in other areas. Check to ensure all methods are deemed secure. Finally, it's very easy for staff to fall into bad habits when handling information in the workplace, particularly with paper information. There are numerous examples where a moment's inattention by staff has resulted in a significant problem, such as the GP leaving notes on the roof of his car and driving off, district nurse having a bag containing records stolen from the front seat of a car, patient records left in an old filing cabinet and discovered by recycling firms, and the worst kind of example when a patient record was left in a meeting room and was deliberately taken by a member of the public wishing to cause trouble for the organisation. All practice will have physical security in place around offices, equipment and storage. Their best advice is to take stock periodically and think, is this security working, or are staff working around it? We're now going to spend some time looking at the quality of information. Much of the public focus on information governance has been on data losses and privacy breaches, generally because these can affect large numbers of people. However, the benefit of quality information, or the impact of inaccurate data, is rarely felt by large numbers of individuals, but can be very acutely felt by the individual affected. To look at a couple of issues, letters can go astray for many reasons, most commonly when patients move. Patients do have a responsibility to inform of changes of address, but many forget and some deliberately don't. As long as practice staff check at appropriate opportunities that the details are still current, then the practice will have fulfilled its legal obligation to have accurate and up-to-date data, as stipulated in the Data Protection Act. The other most common issue of quality is when information is associated with the wrong person. It's vital to ensure that items such as scanned letters are attached to the correct record. If patients with the same or similar names have been confused in the past, it's worth noting on their record that confusion is a possibility, especially where this is within a family, as it can lead to unwitting disclosures of breaches of confidentiality. The worst case scenario of an identity mix-up can be a serious clinical incident. For data to be of good quality, it must be complete, accurate, relevant, and timely. Perhaps the biggest issue in general practice is out of the practice's control, in that information from other agencies such as discharges is not always timely and sometimes incomplete or inaccurate. Entries should also be relevant and appropriate. In the vast majority of cases they are. But be aware of the consultant who wrote in a female patient's record, "This lady reports being abused by her husband. Having met her, I can sympathise with him." Patients have a right to have errors in their records corrected under the Data Protection Act. Any factual inaccuracy in a record should be corrected as soon as it's discovered. Correction should be done in such a way the incorrect data is preserved in case any action was taken on it. In an electronic record, this is done by the audit trail. On paper, the error should be struck through so it's clearly erroneous but can still be read. Many entries in health records are professional opinions, but it's not uncommon for patients to disagree with such opinions, particularly where in their view the opinion may be detrimental to them, such as comments on mental health that can affect life insurance premiums. If a patient disagrees with an entry, it should not be changed unless the clinician recording the data determines this is the best action. Generally, the opinion of the patient is included, but the original entry is not altered. When a patient asks for a copy of their record, in the majority of cases it is simply provided. However, if there is information that is specifically about someone else in the record, that part should only be disclosed with the individual's consent, or a very good reason to do so without their consent. Also, if in the view of the senior clinician there is information that could distress the patient, that can also be removed after careful consideration. Generally, it's better to ask the patient to come and discuss any entries of concern, as removing data is often noticeable, and if the patient notices information being removed, this can be of greater concern. There are situations where relatives often request copies, but it's worth highlighting the circumstances where they have a legal right are actually quite limited. If an individual lacks capacity and the relative has a lasting power of attorney related to health and welfare, they can then have access to information relevant to any decision they have to make on behalf of the patient. However, in a situation where a relative doesn't have a legal right, and the patient doesn't have the capacity to understand and consent, it doesn't actually mean you can't disclose information to them at all. If they've always been involved in the patient's care, and they're knowledgeable about the patient's conditions, and disclosure is in the best interest and of benefit to the patient, it can be okay to disclose information. This is similar to when there is a request for records of a deceased patient. Legal rights of access to information on a deceased individual are limited to the individual's personal representative or executor, or if an individual has a claim arising from the death of a patient. In these circumstances, a claim is generally taken to relate to issues around the financial affairs or estate, so typically where there is a dispute about validity of a will, and where health information may relate to determining this. Disclosure should be limited to just relevant information. As before though, if an individual doesn't fit one of the categories where they have a legal right, the absence of the right doesn't mean you can't disclose anything at all. If disclosure would aid an individual's grieving and would not reveal information the patient would not have wanted to disclose to them, you can disclose limited information. Many requests come from solicitors, often to support personal injury claims. The key items to check are the consent. Does it appear valid? What does it cover? Does it cover all of the record or relevant parts? The wider the consent, the more concerned you may be about whether it's appropriate and it needs to be checked with the patient. There's also issues of relevance. Solicitors often ask for the whole record so they can decide what is relevant. However, this may not be appropriate. Under the Data Protection Act, use of information must be necessary, otherwise it risks being in breach of the Act. It's a clinical responsibility to determine what is relevant, and frank discussion with a solicitor at the start of the request is often the best course of action. Lastly, we'll look at some of the risks to privacy that emerge from the use of new technology and systems. Regular surveys indicate all staff know not to share their passwords and smart cards, but that it still happens. Or computers are left logged into a clinical system and used by more than one user at a time. Sharing is effectively akin to asking someone else to write your notes for you and sign them with your name. Many headline data losses relate to details held on memory sticks. These small devices can hold many thousands of records. One device could hold some details on every patient in the practice. There are several things to consider. Does the data need to be on the device at all? If so, does it need to be identifiable? If so, then it should be encrypted. You may decide to ensure all devices are encrypted. However, the question whether the data is identifiable is still valid. Standard policy across the NHS is to encrypt all laptops. Even if the probability of the device containing personal data is limited, it may well change in the future, and then the security would already be present. Finally, there have been worrying reports about patient and staff privacy being breached on social media sites such as Facebook. Examples have included paramedics and nurses posting photos that could identify patients, and others where members of the public have posted conversations they've overheard about other patients. Issues created by staff are uncommon and can be acted upon. However, issues caused by members of the public highlight how new uses of a technology can have downsides as well as benefits, and that all actions to govern information must strike the balance that was highlighted at the beginning of this presentation. The aim of this presentation has been to both inform and reassure you about how to handle personal data safely and effectively in general practice. As long as you apply this knowledge and common sense when using personal data, you won't go far wrong. Finally, as a bit of light relief, here are a few laws from around the world where maybe common sense was not used when they were written. For example, in Alabama, USA, it's illegal to wear a fake moustache that causes laughter in church. So I guess as long as the moustache is in no way funny, you can probably wear a fake one in church. In Hawaii, it's illegal to insert pennies in your ear. In all other parts of the world, it's just plain stupid. In Scotland, it's illegal to be drunk and in possession of a cow, but presumably it's okay to be in possession of other large farmyard animals. Thank you for listening.